jurisdiction that we did for today. Talk about the statement of the issue that I'm going to assign for next class to write. Talk about Carvin. Talk about Verrilli. Listen to at least Carvin, maybe Carvin and Verrilli in their oral arguments. I'm not going to prep next class's reading because I'm just going to send you an explanation of it. It's pretty complicated, the background, but it's not difficult to read. And then hopefully we'll have time for the Garner game that we didn't get to do last class. So housekeeping, I don't think there's much. Oh yeah, one of the other lawyering skills professors, Holly Hopkins, is bringing some guest speakers that you all are invited to if you want to go. It's not in any way mandatory. That's Wednesday, February 20th, in room 275 at 2:30 or 3 o'clock. She hasn't worked that out. And then for homework next class, read Chris Landau's excerpt that's number 4 in the supplement 2. Read Judy Fisher, page 94. Thought we were going to have no more Judy Fisher readings, and then I checked. Today we haven't, and actually then I was like, all right, was this the last one or not? No, it's not the last one. So for those of you from last class, when I said this might be the end of Judy Fisher, you had these looks of panic on your face, like you were going to miss her, and just like it was going to, don't worry, fear not. She's not going anywhere for now. Okay, and then do the statement of the issue. All right, that's it for housekeeping. I sent out an email. The sign-up sheets for next week are by my door, so feel free to do that after the class if you want to sign up today. Okay, practice tip of the day is if you have an ethics question, ask someone. Seems like the most obvious of advice, but you'd be surprised. And here's a little trivia, or take a guess. What are the most, okay, so actually 2 questions. One is, what types of attorneys get the most ethics complaint? Yeah, Emily?
Probably torts, because you've got whatever.
Let me rephrase it. Like at what size firms?
B.
Yeah, Kelsey.
Large.
You might think so.
Small.
You might think so. Small. Any guess why?
You don't have people checking behind their backs.
It's not so much that you don't have like someone like snooping or like reviewing, but I mean we don't know for sure why, but I think the reason is there's no one to ask. Right? It's like you're on your own. You don't know every rule in the book, and so like if you don't know something, you can't like walk down the hall and be like, hey, like what do you think? And you know, big firms, like huge firms, have like a permanent ethics like office. So but that's even at a mid-sized firm, there's more people to ask. What types of complaints do you think lead to the most? What do you think are the most common ethics complaints by clients? Yeah, Emily.
Maybe like getting back to people.
Yes, returning phone calls. So do that. Return your clients' phone calls. And then also mixing funds, money stuff. So like, and again, that's probably easier to do with a small firm than a big firm. Big firm, like you never even like see the money that your client like pays in. There's big accounting offices and things like that. But a small firm, like they send you money and you mix it with your money, and that's a no-no. So anyway, many ethics problems arise in solo firms when it's not convenient to ask for advice because there's no colleague to ask. If you can't ask a colleague, either you're at a solo practitioner or a small firm and your colleagues are out for the day, or maybe you just don't like your colleagues. Maybe your colleagues are unethical. Hopefully that's not the case. You can call the KBA, and they have like a list of like private attorneys on a list that are like, it's like an ethics hotline, and you call them. Although I will say I did that once, and the guy was like 110 years old, and I had a question that was like, it wasn't like a cutting edge question, but like it wouldn't have been a relevant question in 1920, and so he was no help whatsoever. So he's probably dead now. I'm not happy he's dead. It's just an observation. Okay, so let's do your statement of jurisdiction. I didn't. It's fine. It's pretty nice. So let's take a look at the template. Which how many people could not open?
I
didn't even try. I don't even read your emails.
Just copy and paste the emails like I'm not going backwards.
So the attachment hasn't been an issue in past years, but clearly it wasn't any student's fault. It was clearly an issue this year. So, oh yeah, I should turn this on. Ah, that's the wrong button. Oh, now it takes about 25 minutes for it to like come back on.
Who wants s'mores?
Disaster. Disaster. Let's see if it really takes. Surely it doesn't take that long. Okay, good. Okay. Okay, so here's the statement of jurisdiction template, and let's walk through. Well, actually, I'm not even walking through because it's such an artificial kind of exercise because our case is not in an actual court. So I'll just walk through. The district court has subject matter jurisdiction because defendants, but we don't have multiple defendants. We have only one, so that should be changed. Work was charged with a federal crime. I checked. What was our guy charged with? Murder. No psych fans out there? Clearly not. And then we're just going to pretend like that's the relevant statute because we're going to pretend we're in federal court for the purposes of this exercise. This court has appellate jurisdiction under that statute. Judgment against our guy's name is not Conrad Black. Our guy's name is Miller, I think. Yeah. So judgment against Miller was entered on, and we'll fix the date, and we'll fix where in the record it is, and we'll fix the date that he appealed. We'll fix where in the record that is. I learned in going back and doing this, our guy's attorney was Johnny on the spot. He appealed same day as the judgment. Maybe he was just like, I guess he saw you see coming to the jury's already conspiring. But in any event, here's the right answer, or a version of the right answer. District court had subject matter jurisdiction because defendant, and actually, I like articles, the defendant was charged with a federal crime. This court has appellate jurisdiction. Judgment against Miller was entered on this date, and the judgment was page 3 to 4 of the record. And he appealed on this date, same date. You could say he appealed on the same day. That would be fine. And it's on page 1 of the record. We've really gotten a lot of use out of page 1 of the record this semester. A lot of legs. I want you to learn how to do a statement of jurisdiction. I'm actually going, here's what I'm going to say. Don't put it in your brief. It's just so, it's so far removed from the brief that we're doing. Just don't put it in. I'll send out a new rules of appellate procedure, and you'll see we will not have that in your brief. If this were in federal court, we would need a statement of jurisdiction. Okay, questions? So where are we now? Okay, statement of the issue. So your next is thing, right? Your next draft is going to be a statement of the issue. If you've looked at any of the full briefs that I've sent out this semester, they all have a statement of the issue in them, and they're not bad examples. Although we tend to read cases that are more pure questions of law, not questions that are mixed law and fact. Our case is more a question of mixed law and fact. So what does the Confrontation Clause mean? And once we explain that, how do we apply it to our facts of an autopsy report? The Brady memo that you did last semester had a deep issue statement. That's a kind of a good model for a statement of the issue. Statement of the issue doesn't have two sections like that, but it's kind of accomplishing the same point. Right? A sentence or two, kind of like law and fact, and then a question. Another place to look is the Garner section on deep issue statements that we read last semester. Today's brief by Michael Carvin, I thought, had a very effective question presented. If you have to look at the actual attachment that I sent you, because it's not in the excerpt. What is the purpose of the statement of the issue? What do you, just from the sound of it, Sam, what do you think the purpose of a statement of the issue? It's going to come right at the beginning of the brief, or very close to the beginning of the brief, and you're going to tell the court, here is the legal issue. So, like, what do you think you're trying to do as a writer there?
Just to summarize your the whole point of writing your 30-something page brief into a paragraph where the judge can immediately pick up what the issue is and what to look for as far as a question about how to answer it, I guess.
Yep. It's kind of like a blurb. Like if you were gonna here's what this book is about. Here's what this brief is about. But you also, now that we're writing a brief where we're trying to persuade our audience to rule for one side, whereas in the memo you were just trying to persuade your audience that you had kind of objectively analyzed the law. You want to try to slant it toward your client a little bit. So let's take a look at some examples from last year, and I'll tell you what the case was about, and then you tell me whether you think that the statement of the issue was written for the school or for the student. So let me tell you, here's what the case was about. And you can also be thinking whether you wish you had gone to law school a year earlier and had last year's fact pattern. Remember last year? Sure. The flying spaghetti monster. So the school board began each school board meeting every month with a prayer, and they would invite members of the student council to give the prayer on a rotating basis. Student council members were required to be at the school board meeting, although they weren't like punished for opting out of the prayer schedule if they chose to, of the giving the prayer if they chose to. And so our client, I forgot his name, Phelps? Does that ring a bell? Colin Phelps. Wow, better memory than I have. I read 44 of those briefs. Colin Phelps didn't like this very much. He thought it was unconstitutional, and so he gave a prayer to the flying spaghetti monster, who he said, like, my God is the flying spaghetti monster, and please bless all the pasta. Yeah. There's so just like we got into it. There's, it's debatable whether it's, he anyway. I don't want to get into the narrative of it. I just want you to see how the statement of the issue. And so there are precedents out there that say you can't pray in schools, public schools, when you're in grade school, high school. Or you can't be required to. You can't be led in a prayer. But there are also precedents out there that say it's okay to open up a legislative session with a prayer, like Congress does that, or it's okay to begin a town council meeting with a prayer. So like if the Jefferson County Metro Council wanted to begin with a prayer, as long as the prayer doesn't proselytize, the court has said that's okay. So prayer in school, not okay. Prayer before a town council, okay. Legislative prayer. And so then the question in our case was, well, is this more like an unconstitutional school prayer, or is this more like a constitutional legislative prayer? Okay, so let's look at some of these state of the issues, and you can kind of see how some of these students did a nice job of slanting the issue toward them. You can also get an idea of kind of the length we're looking for and kind of the structure. So Phil, we'll start with you. This first one, is it just me? Is it small? It's not small for you all, is it? Your eyes are not crap.
Speak for yourself. No, I'm basically blind, so.
Okay, well, and that's about as big as I can get up there. In Levy, Weissman, and Santa Fe Independent School District v. Doe, the court held that student-led prayer violated the Establishment Clause because the prayers endorsed an official religion and coerced children to be a part of the religion. Applying Weissman and Santa Fe to our case, was the Establishment Clause violated when the prayer given by a child in front of the other children was mandatory and then ridiculed by authorities when it did not meet their standard? Oh yeah, I forgot to tell you that. After he gave the Spaghetti Monster prayer, the school board said, you don't get to pray next time when it's your turn. Okay, so, and that's when he sued, and challenged this whole practice. Okay, so Phil, do you think that this was written from the schools, by the school's lawyer or by the student's lawyer?
Student's lawyer.
Yeah, and what are some giveaways there?
Based on the choice, especially in the last sentence, or the question, I guess, then ridiculed by authorities.
Yep. So it's got some like kind of negative connotation in terms of what the other side did. It also begins right away by focusing on the precedents that are good for the student, the school prayer precedents. It emphasizes that this guy was a student, calls him a child, says, and then 5 words later says children. So it's really emphasizing the point that like because the court cares. Like they're not too worried about adults like being exposed to prayer, but they're really worried about like impressionable kids being like made to feel uncomfortable by authorities praying. So he really emphasizes, or she really emphasizes, that this guy is a child, and it was in school and it was mandatory, and that the authorities ridiculed that kind of thing. And focuses on the precedents that are good for them. Okay, let's take a look at this one. Jacob, I'll head your way. Okay, so like many deliberative bodies around the country, the School Board of Hightower, Indiana opens its meetings with a public prayer. Members of the Hightower High School Student Council facilitate the prayers on a voluntary basis. Attendance at these meetings is mandatory for student council members. The content of the prayers in question is drawn from a wide variety of religious traditions. Does the school board's practice violate the Establishment Clause of the First Amendment? I'll just say right now, I think there's a sentence or so that's like a little too much. It's a little long. But I do think it does a very nice job of framing in terms of in favor of one side. So Jacob, what side do you think this is written by?
Definitely the school board.
Yep, and why do you think that?
It's written kind of clinically with no emotion really like the last one. And also it compares it to a lot of other deliberative bodies around the country.
Mm-hmm. Yeah, exactly. So I think you're right on both counts. The tone is, saying there's nothing to be outraged about here. It's just status quo. I don't know, nothing to see here. Whereas the first one is like, this is really outrageous what happened. And then it doesn't focus the reader's attention on precedents that ban school prayer. It focuses the reader's attention on all the deliberative bodies around the country that do this, and the court seems to be okay with that. And then it also, it emphasizes that the prayers were on a voluntary basis by the student, which the court's going to care a lot about. Like, obviously the court doesn't think anybody should be like gun to the head, like say like, pray to my God, or you're going to shoot you. But it's like voluntary, whereas the first statement of the issue by the student didn't mention anything about this being a voluntary practice. Talks about the wide variety of the religious traditions, so that's a fact that the court's going to care about, because again, the court will not allow a prayer practice that's main goal is to proselytize in favor of one faith. But the court has said, we're kind of okay as long as like there's a diversity of religious traditions represented. So you'll read maybe one of the most ridiculous cases ever written, I think, by the Supreme Court. They decide on the same day what Christmas decorations the government can display. And so in like one city, there's like a Christmas tree. And they're like, no, that's not allowed. But then in the other city, there's like a nativity scene, but also a secular Santa Claus and a menorah there. And they're like, all right, that works. Like, as long as you've got like Santa, like it's just like, it's crazy. Anyway. I'm not saying that either of them are wrong. I'm saying they can't both be right. Like the decision cannot both be right.
I think it had to deal with the placement of the Christmas tree for...
Yeah, one of them was like, it's
tree was like right
displayed on the grand staircase of the county courthouse. The grand staircase. I mean, like, you've seen like a court. Anyone ever feel like it's just the stairs? Grand staircase. Yeah, I know, but it was, reasonable people could disagree, but it's crazy. I said, I wonder if I could do this. Well, I can't. It's not worth it. You won't enjoy it. It's one of those, my wife accuses me of making jokes where I'm the only audience for the joke. That's all right if the joke takes 10 seconds. I'm not going to take 2 minutes to set up this joke, but anyway. Well, I'll just tell you. I won't. My daughter at Disney World had this castle, and on the box of the castle, it says, it like points to like all the great things about this castle, and it puts this grand staircase. So I texted it to my friend. I said, no nativity scenes allowed. So, all right, see, it wasn't really worth the punchline. Made me happy. Okay, here's the next one. I don't know who's next. Shelby. Legislative prayer, while religious in nature, has long been understood as compatible with the Establishment Clause, quoting Town of Greece. Hightower Community School Board Trustees begins each school board meeting with a prayer led by student council leadership on various religious leaders, by the leadership or by various religious leaders in the community before conducting business. All religions may participate so long as they are respectful to differing beliefs. Does a school board constitute a legislative body, thus allowing prayer and the power to deny religious satire from its meetings? Last sentence kind of makes no sense, but that aside. What do you think? I'm sure it wasn't yours.
I hope not. I'm like, what's that?
So what do you think? Is this written from the student perspective or the school's perspective?
The school's perspective.
Yep, and why is that?
For me, it's the citation or the quote at the beginning.
Yep, exactly. It begins with this quote that says, even though legislative prayer is a little bit religious, it's compatible with the Establishment Clause. It's perfectly constitutional. And then it kind of gives some facts, and the facts are facts that are good for the school. That all religions may participate. They have to be respectful of differing beliefs. That's kind of anticipating the argument that the school board discriminated against Phelps because they didn't like his particular religion. But what they say is actually, we don't have any problem with your religion. We have a problem with you creating a religion whose only point is to mock other religions. I know, but I'm summarizing their argument. Of course they are. So, does a school board constitute a legislative body? So again, frame the question. Like, is a school board a legislative body? Well, like, seems pretty obvious. Anyway, so asking, almost creating like a straw man to then knock it down. So, is this about whether Pastafarianism is official religion? And Emily's right. You're right on all that. I don't want to get into the merits of the case. Or start any holy wars. So.
I'm just noticing like wording where they say like while religious in nature.
Yeah.
It's like they're toning down the fact that like there's no religious in nature. Prayer is religious. Period.
Yeah.
Like, but then at the end, you know, they talk about religious satire. Like at the beginning, it's like they're trying to tone it down, but then the point they make at the end is like this is so offensive because it's somebody else's religion that you're making fun of. It's like, I don't know.
You're saying that this is effective or ineffective?
I feel like it's, well,
or it's just
good
contradictory?
wording, but I feel like attacking it from the other side of it is like, well, you're trying to act like it's not this huge religious thing,
Mhm.
but then your argument is also that it's extremely offensive because it's religious.
Yeah, and so part of that is just like, you know, you're stuck with the case, and the attorney for the student has to argue two things. One is the practice in general is okay, and number two, the prayer to the flying spaghetti monster is not okay. And so, you know, the contradiction you're pointing out, the tension that you're observing, I think is just a tension that the attorney is stuck with. Like, the attorney, it would be an easier case to argue if there weren't that internal tension, but we made it hard for the students. We made it hard for both, for the school board and the students, I think. It was a good issue. Let's take a look at this one. And let's see, Logan. Okay, under the First Amendment to the United States Constitution, the Establishment Clause prevents the government from doing two things in regard to religion. First, government cannot endorse any particular religion. Second, government cannot coerce individuals into participating in or accepting any specific religion. So, by the way, just stop right there. Rule explanation or rule application? Explanation, yeah. I mean, it's pretty detailed, and maybe too detailed for a statement of the issue, but in general, I think it kind of works. This person has, in 3 sentences, explained the rule. Rule for the Establishment Clause. Government can't endorse, government can't coerce. Okay. A school board meeting, now he gets into the facts. School board meeting gave a prayer at the beginning of every meeting each month. Student council members were required to attend, and children were present. Also, the school board did not allow a student to give the prayer of his choice when his turn came. Under the Establishment Clause, does the government endorse and coerce when it requires attendance and prevents individuals from giving the prayer of their choice? So, the student, or this writer, do you think that she was on the government side, the school board side, or the student side?
Definitely the students.
Definitely the student side. So tell us why.
Well, like it explains the rule and talks about how you can't coerce or force, and then when it explains like kind of the facts, explains how children were present, they weren't allowing them to like pray in the style they wanted, and then the question that they ask is basically, did the school board violate the clause, Establishment Clause? So that's from the student's perspective.
Yep, I think everything Logan just said is right. I think the last sentence is well done. Requires attendance. That's a fact that this writer wants you to focus on. That's a fact that's really good for the student. required to attend where someone said a prayer. And then also prevented him from giving his own prayer, prevented Phelps from giving his own prayer, prevented him from giving prayer of their choice. So those are like probably the two best facts in the record for Phelps. And so this writer makes sure that those facts make it into the statement of the issue. Also, I love the line there, children were present, you know, as if it's like an X-rated movie. It's like children, they said a prayer and the children were present. But the court's into that. The court's really, really worried about children being kind of like intimidated into praying. So it's that. I think that's a nice touch. Yeah.
So do you like that a lot? How he set the rule up, the explanation?
Yeah. I always wish that what's done in 3 sentences would be done in 2 sentences, if it can be done.
Okay.
So, you know, if I were writing this, I might take a shot at making it a little more concise. But I like a sentence or two on the rule explanation. I like a sentence or two on the facts, and then the question. Okay. Questions? Okay, let's talk about Michael Carvin, Don Verrilli. One of the things that I like about today's readings, so many things, but they have very different styles. You'll see the different styles a little bit more in the oral arguments than you will in their writing, but you still see it in the writing to a degree. Carvin is the most aggressive attorney we'll read all semester, especially maybe tied with Tom Goldstein. He's like a madman, not like the madman in the 4 phases of writing madman, but he's like just like okay. And whereas Don Verrilli is like, you know, 3-piece suit and like the epitome of the establishment and like, you know, just very like structure and you know, just the facts, man. You know, you can drag that. Whereas Carvin is like, you're, you know, so stupid, and the other side has no. Anyway, there's place for both. Here's the background for this reading, and here's why I'm going to tell you the background in some depth. Because although writing, including research, is the most important lawyering skill that we practice and talk about and learn throughout the year, there are other lawyering skills that we try to encompass. And so it's kind of like grand strategy is not a lawyering skill we talk about a lot, but it is you know, a good skill to be able to have, regardless of the case, kind of like being able to play chess against your opponent instead of checkers. Here's the story. There was this case called Knox. And what happened was a union in California, public sector union, made what was a strategic mistake. And this is the first lawyering thing to think about. What were their lawyers thinking? Okay? Here's what they did. There was a referendum on the ballot sponsored by Arnold Schwarzenegger back when this was like after he was a movie star. Before he was a disgraced politician, there was like about
The governor?
3 minutes there, yeah, where he was like an effective governor, or like arguably effective governor. Or I don't say effective, but popular enough governor, okay, popular governor. And for the babysitter thing. And so he sponsored these referendums, and the public sector unions hated the referendums. So they created a fund to oppose them, to like run commercials against them. And all that's fine, but they used dues not just from their members, but from their non-members who are required to pay what's called agency fees. So you may have seen this in the reading a little bit, but if you work for the government and there's a union, you have a choice, join or don't join. If you join, you pay union dues, and the union can do whatever they want with that. Just like if I pay dues to Planned Parenthood or National Rifle Association or whatever, they can do whatever they want with my dues. I'm paying them. But then there are people who choose not to join the union for whatever reason. Maybe they just like are stingy with their money, or maybe they oppose the union's agenda. And so if you don't join the union, in California and in about half the states in the country, the government allows the union to require you to pay a partial dues. They require you to pay the dues that the union will later spend to collectively bargain on your behalf. And the idea was you don't get to free ride. The union is bargaining on your behalf, so you should have to contribute to that. But the union's not allowed to spend that money on political stuff. Okay? So what does the union in California do to oppose Schwarzenegger's referendum? They take everybody's money, right? All the agency fees are supposed to go to collective bargaining, and they use that money to fund what they name. They could have named it anything they wanted. They named it a political fightback fund. Right? This is money that you're not allowed to use for political speech, and their lawyers let them name it a political fightback fund. Right? So that was mistake number one. So this case goes to the Ninth Circuit, and the Ninth Circuit actually rules in favor of the union. The Ninth Circuit is very kind of pretty pro-union circuit. But the Supreme Court grants cert. And at that point, the lawyers for the unions, okay, here's the next strategic thing, and this I think they were pretty clever on. They're like, oh shit, now we're in trouble. And we might lose more than just this case. We might actually get an opinion that sets some bad precedent that will screw us over in the future. So what do you do? What do you do if you're the union's attorneys in this case? You've won so far, but the Supreme Court has decided to take the case, and you're worried that as a result, you'll not just lose this case, but you'll lose future. You'll be in worse shape than you were before any of this even started. Any ideas? Yeah, let's go.
Can you try and come up with some kind of agreement to get the other side to drop it?
Yes, that's exactly right. And the other side doesn't want to drop it. So the agreement you come up with is give them everything they're asking for. Right? No compromise, just give them everything. And so they conceded everything, and they even sent nominal damages to each plaintiff. So they literally sent a $1 bill as nominal damage to each plaintiff. So they tried this, and so then they write a brief to the Supreme Court saying, you don't need to hear this case anymore, it's moot. Right? It's already over like weeks. And the Supreme Court said, not so fast, we're still going to hear it. Because why? Because why? The Supreme Court's like, well, you're not going to stop us from making some law that we think is important to make. So anyway, so it goes to the Supreme Court, and then their worst nightmare happens. Because at the oral argument, the justices aren't just asking questions about this case. They're asking questions like, hey, you know that distinction between political speech and non-political speech that allows you to require non-members to pay for non-political speech? Maybe that distinction is a distinction without a difference. Maybe that line is a non-existent line. Maybe you shouldn't ever, forget this case, ever be able to require non-members to pay. Well, now we're talking about billions of dollars in dues that they might not be able to collect in the future. So they're really wrong. So the case comes out, and it doesn't outright say that they can't do it, but it does hint. It does hint. And so now put yourself, here's the third strategic decision to make. Now you're on the other side. There's a precedent from 1977 that allows this status quo. It allows the unions to collect collective bargaining fees from non-members, so long as it's not used for political speech. And that precedent is called a boot. It's from 1977. It's been on the books for a long time. You're on the attorney for the other side. What do you do? Now this opinion has come out. No ideas? What do you say?
You just push it further.
Push it further, yeah. You go find some public sector worker, doesn't matter who, and you're like, hey, want to sue your union? And we'll do it as a class. We could make it a class action, or even not. Doesn't really matter why you go through. Why make it a class action? Because that takes time to certify the class and all kinds of things. Let's just you got 3 or 4 friends who also want to sue their union, or their non-union, the union they chose not to join. Let's do it. We'll sue. So they do that. And that's this Friedrichs case. In the meantime, though, the court has granted another case, and they kind of chip away even more. Okay, so fast forward to that. So now you're the attorney for Friedrichs. Friedrichs is the worker that you found who wants to sue the union, and you go to district court. It's where you file suits, and you know that the Supreme Court has 5 justices who are going to rule for you in the future. I mean, you don't know that 100%, but you know it 99%. They have really hinted in their opinion at Knox that they hate Abood, they hate the status quo, they're ready to like have a little revolution here. So, but that old precedent is still on the books. So now you're the attorney for the union, you're attorney for Friedrichs. What do you do at the district court level? You sue, and then what do you do? What do you think? 4th strategic choice to make. Elizabeth?
Do you maybe, I don't want to say try to lose.
Yes, yes.
Okay.
You don't try to lose. You just try to lose quickly. You know you're going to lose. Because the district court doesn't get to overturn Supreme Court precedents. Abood, 1977, is a precedent. The district court doesn't get to overturn that. So what you want to do is you know you're going to lose, so you want to lose as quickly as possible. So you basically say to the district court judge, I know we can't win in your court, just rule for us as quickly as possible so we can appeal. That's what they do. And they get to the Ninth Circuit and they say the same thing, rule for us as quickly as possible so we can take this to the Supreme Court. Now, 5th grand strategy decision. This one, now you are Solicitor General to President Obama, right? You love the unions. You hate the idea that this Abood precedent is going to get overturned. It'd be a major blow to many of your political supporters. What do you do? Obviously, you're going to oppose the challengers, the plaintiffs, Friedrich, when it gets to the Supreme Court. The Supreme Court has asked you, and this is where that other case comes in, has asked you your opinion, which is kind of a normal thing. Often the Supreme Court will solicit the views of the Solicitor General. And usually the Solicitor General turns that around in a few months. What do you do if you are Solicitor General Don Verrilli and you've been asked for your views on this case? I forget what even number strategic choice we're on. I think it's 5 or 6. Any guesses? Okay. You're thinking as not just an attorney who's trying to like win on the merits of the law, like try to persuade on there. You're thinking like as a counselor to your client, strategically, what you want to do. And here's a hint: about half the Supreme Court is like 80 years old. Yeah.
Do they have time limits? Like, can they take forever? And then wait for someone to die, and then Obama can put someone on there to... Okay.
So normally they take 2 or 3 months. I mean, if you waited forever, then you would lose credibility with the court, and like you're a repeat player. So you don't want to like totally burn that credibility that you've built up over decades. But they didn't take forever, but they took close. Right? Solicitor General Verrilli, instead of taking 2 or 3 months, he took 11 months to tell the court the Solicitor General office's opinion on the case. Delay. So that comes in, and the court's like, all right, and of course his opinion was, we don't think you should take the case. The court's like, all right, thank you for your opinion, finally. We've decided to take the case. So they take the case. They hear the oral arguments. We're going to listen to them. Carvin versus Verrilli. And then here's where Verrilli's strategy paid off. It looked like it was going to pay off, just almost beautifully. What happened? Anybody remember what happened in the fall, in February of 2016? Scalia died. This is like, I mean, I'm sure Don Verrilli like didn't wish Scalia's death, but this was like the only way to win the case, is to have one of the 5 out die. And so he did. And so it looked like after the oral arguments, but before the decision came down, oh my gosh, this is going to work. We're going to win this case. And then so then the rest, you know, like Scalia, Garland didn't get picked, and Gorsuch comes in, and Gorsuch votes the same way as Scalia. So at the end of the day, the strategy of delaying and hoping for Scalia to die, or Kennedy to die, or one of the conservatives to die, didn't ultimately work. But it came really close to working. And so you can see all of these kind of like strategic moves that these people were making. So again, I think we had someone, a guest speaker at the very beginning. You know, your attorney is looking for more than just like a writer or researcher. Your client is looking for a counselor and a strategist. So think about all these things as we read this case. Okay, so let's take 2 or 3 minutes, talk about things that you think Carvin or Verrilli did well, could have done better, and then we'll share.
Oh. All right. Thank you.
Honestly, I found the first one hard to read.
Read them both? Yeah, but so
I thought this one was like really hard to read.
So I said the second one, the thing I was so confused because I read that and I'm like, okay, a booth, right? And then the next one's talking about a booth. I'm like, why did one guy write on two sides of the same case?
These don't like in the book. It doesn't have a page break or whatever.
Dude, I thought Frederick was the guy who writes. So I'm like, why did he write both sides of the case? Like, I didn't realize. Yeah. But I'm like, this is two
He just switched up.
Yeah. So I was so lost.
You thought it was the same writer?
So anyway,
He thought these were different cases?
yes, I believe the case.
And then it just switches over and starts arguing for the other side?
So that's why I said on the second one, I'm like, yeah, and this
That
one.
move was correctly decided.
That's why I was like, this morning I'm leaving my house, I'm like, if I didn't know, I would have thought it was written by two different people. Like, literally was thinking that when I was getting into my car. Because I was like, this one's much easier.
Yeah, this is like he said, this is like a crazy dude just rambling.
I needed a
This one
dictionary
had,
from beginning to end. This one, I didn't really have to pull it out. I was like,
yeah, well, this guy didn't lay out like any, like this one, it has like, I don't know if it's a statement issue, but like, has what it's going to talk about, like what his point is, that holding to be reaffirmed, what the court even held. This guy just starts talking about Thomas Jefferson.
bro, it made so much sense once I just came in here, like this past 20 minutes. I was like, why did he write? Like, I thought it was two different cases. Yeah. It was like, lady. Oh my gosh, it's so funny.
That was my biggest thing. This one like had a lot better. What's it called? Like framing, like the sentence framing. The first sentence was like a summary or
You
whatever.
don't get the shirt?
I don't get it either.
When
there are nine.
Is it like the 9 justices, but is it like, when will there be enough women?
That was interesting.
When there are nine, I don't get it.
You know what?
still.
When you do the RPG thing, you should definitely wear the shirt. I think I'm going to bring some cool. Because I'm just increasingly amazed at cult RPG. And that's how cool. I think that's how cult is, right?
Sometimes it's because of the FBI.
Or what? Or
doing that's not cool.
I didn't even hear it.
All right. Let's.
You said RPG. I thought he was saying RPG.
RG3. RG3. No,
Okay. Let's see. I'm gonna do a little differently today. I'm gonna start with some things that I like about each brief, and then hear what you all think. So if you start with Carvin on page 14, first page, 14 of the supplement, 16 of the brief. First of all, I like how he framed. I like his theme. What do you think his theme is? I mean, writers usually have more than one theme, and sometimes they don't even think consciously about what their themes are. But they usually have a good writer will always have a theme, and sometimes more than one theme. So, Michaela, what do you think is Carvin's? How is he trying to frame this? What is his main message? What is his theme?
I have no idea. Like,
I'll give you a hint.
I read it and I didn't. Yeah, like it was mostly like the First Amendment Constitution, but I was just like, I hated it. Like, I had to like Google stuff and everything.
Same.
I had no idea.
It was
what
hard
he
to
was talking
follow.
about. Yeah, I had no idea what he was talking about. Then after I Googled stuff and went back and read it, I was like, oh, I get it now.
Okay,
But
so
I
what
didn't
did you
get
have to? What did you have to? We're gonna put that up later. But what did you have to Google? So, and this is a flaw of Carvin's. I mean, you don't want people to have to look things up when they're reading your brief.
Like, I guess he's using quotes from other cases in the Constitution and stuff. If you look at constitutional writing, it's not regular English.
Mm-hmm.
So it's like, what does this mean? Like, so I looked up a lot of words, and then too, like he talked about a boot a little bit, but he never really actually told you what the case was like monumental about, so I had to look up Abood to figure out what it was about. So after I like read a million things and then read this, I was like, I understood, but I just didn't.
Okay. So, I think that you always want to write to your audience. His audience here is going to be pretty familiar with Abood.
Right.
So maybe that's not a strategic mistake of his. You can't usually assume that your audience is familiar with the precedent, almost ever. But in fact, even if the judge has written the precedent, the judge still might not remember the name of the precedent. This Abood is a bit of an exception because by now, this is like the third or fourth iteration of this case. And so he's pretty sure that the court is familiar with the precedent there. On the quoting old stuff, I think that like I agree with McKellar, don't quote old stuff if it's written in a way that's hard to understand. I'm not sure I agree with I'm not sure the audience would have struggled with the stuff that he quotes, but different audiences are going to be different, so it's something to keep an eye out for. I do think that if you talk about, let's fast forward to Verrilli's brief for just a second. You don't have to flip. I think this is Verrilli's theme. I was thinking this morning, like, how can I picture Verrilli's theme, right? Verrilli likes this, and he's saying if the other side wins, it's like this. And so, who is he appealing here to? He knows he has to get 5 votes. He knows he already has 4. So he's got to pick off one of the 5. And so I think what he's trying to say is, to one of those 5, I know you hate unions. And I know that you love political speech. And I'm not asking you to change that. But there's an exception. When the government is the employer, the man is the man. The government is the man. We can't have all these government employees running around and not doing what their employer says to do so he's saying we want some stability in the workplace. We want some order, right? So he's saying, I represent stability. My theme is stability. Whereas Carvin's theme is right? This is free speech we're talking about. This is the First Amendment. This is freedom. And so, we're gonna break through whatever walls we have to break through to make freedom. So what does he lead with as he frames? He's going to look at the subsection 1A heading, government coercion of individuals to support political speech must set. We're talking about coercion of speech here. And he leads with, and I think that the 3 quotes he leads with are pretty effective, at least for this audience. He quotes Thomas Jefferson, then he quotes the Supreme Court's opinion in West Virginia v. Barnett. This was a precedent where the school board had said to a little kid, Jehovah's Witness, you have to stand and salute the flag. And the kid said, well, that's against my religion. So we have to do it anyway. And the court said, no. In America, we don't force people to say stuff they disagree with. And so that's the quote from West Virginia v. Barnett. And then he ends with this last quote, Harris, that's one of the cases I was describing earlier. I think it's a strategic choice in terms of knowing the audience there. And then look at the bridge. Look at the bridge in every paragraph, beginning with page 16. And we're going to walk through these. Right? The court has thus consistently applied exacting scrutiny to compel subsidization. So the word "thus" there, that stuff I told you, as a result of all that, that's why the court has done this exacting scrutiny. And then the next paragraph on page 17, bridging word there, similarly, right? That stuff I just told you, well, there's something similar to that, and now I'm going to tell you about this similar thing. Then you go to page 18 of the brief, 16 of the supplement, the next paragraph there. Given that compelled subsidization of speech and mandated association receive exacting First Amendment scrutiny, I think that's kind of hard to follow in terms of the wording, but I like that he's doing a bridge. Given that stuff I just told you, right, such compulsion clearly receives blah, blah. So given what I just said, the result is given X, the result is Y. In the next paragraph there, first of all, I think I like that the section uses a break to shift and kind of break things up for the reader. But then it still has the bridge. Just as the government cannot compel political speech and association generally, just as the government cannot do the stuff I just told you the government can't do, it also can't do this other thing. Then look at the next paragraph. All right, I just started with some general stuff. Now let me give you an example. Right? That general rule I just said, here's an example about that general rule. For example, Elrod v. And the next paragraph, page 19 of the brief, 17 of the supplement. Right? I just talked to you about some exacting scrutiny. That same exacting scrutiny that I just talked about, it applies here. The bridge after bridge after bridge. Next page. Indeed, unlike patronage, I just talked about like patronage stuff, and now I'm going to say, unlike that patronage stuff, blah, 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 blah. So I think that's done effectively. Look at the next page on page 21, done with the bridges. Last paragraph there. The dissent, this is 19 in the supplement, the dissent in Harris suggested that compelled subsidization of collective bargaining speech is permissible because the content of that speech is not ideological issues of public concern, but involves prosaic stuff like wages, benefits, and such. That is of no public concern. The dissent in Harris is basically the same as his opponent's argument here. So what he's saying is, the dissent in Harris, my opponent's argument here made this point. What is he doing there? He's setting up a counter-argument. He's saying, I acknowledge that there's a counter-argument to my position, but now that I've acknowledged it, I'm going to knock it down, or at least I'm going to try to. And I'm going to knock it down with a roadmap. I'm going to start with a roadmap. So we see another writing principle here. That contention is contrary to 1, blah, 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 2, blah, 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 3, blah, blah, blah. And then, look at the next page, page 23, supplement page 21. Look at the research that goes into not just this page, but the next page as well. The table of contents, the table of authorities is 11 pages long. What did we say last class? What's the most important thing about writing? Research. 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 You can't write anything well if you don't have something good to say, something worth saying. So his research, 11 pages long table of authorities. And look how he uses it here on page 27 of the brief. There's actually something I like even better. Oh, sorry, page 25 of the brief. He has not just researched the precedents, he has researched the oral arguments that preceded the precedents. And what has he found? He's found this quote from Justice Kennedy, an oral argument in Harris. And the quote basically says, I agree with Michael Carvin. So why wouldn't you put that in your brief? Why not remind Justice Kennedy, a vote that you need, that he has already endorsed your position? So I think it's a clever use of oral arguments, very relevant. And then I also think we talked last semester a lot about knowing your audience. Knowing your audience. So here's the last thing I would point out, page 27, 25 of the supplement. What does he say here? One recent study analyzed the collective bargaining agreements in the nation's 50 largest school districts and found that unions have generally bargained for a rigid salary scale that evinces little regard for individual competence, extensive labor rules that hobble managers from efficiently assigning and terminating teachers, contracts that routinely stipulate the number of students a teacher will instruct, et cetera, et cetera. And also this ties into the previous page. In 2013, the total cost of wages and benefits for state and local workers was $1.2 trillion. 1.2 trillion, half of the total spending by state and local. So what is he doing here? I think what he's doing is he's doing the ultimate knowing your audience. He knows that his audience dislikes two things. His audience dislikes big government, and his audience dislikes unions. And so he is just throwing red meat at his audience. This would be a terrible brief if you were writing to a left-of-center court. But this is an effective brief when writing to a right-of-center court. Because he's saying, I'm going to, $1.2 trillion. And what is the result? Rigid salary scales and hobbled managers and schools that don't work. And so he's saying to his readers, all that political bias you have against big government and against unions, embrace it, channel that. And so, you know, it works. It works. It may not be the way the law should work. You know, if you're left of center, you hate when conservative courts kind of unleash their political biases. If you're right of center, you hate when liberal courts unleash their political biases. But if you're an attorney, you know, you go to court, you go to war with the court you have, not the court you want. Okay, things that Verrilli did that I think are very effective. page 12 of Early's brief. Let's see if I can find this. Okay, yeah, page 34. What does he have to do? He has to pick off one justice, one of the 5 who are in play. And so you can see here he knows his audience. He's going after Scalia. Look at what he quotes in the middle of page 12. A Scalia dissent. Usually you don't quote dissenting opinions. Why is it silly to quote a dissenting opinion usually?
Not good law.
Yeah?
It's definitely not
The law.
Yeah.
I'm trying to figure out the right word for it. I can't. It was just it was like on the chart.
It's not a holding. Yep, there you go. It's not a holding. It's not the law. It lost. The dissent lost. So why would you quote the side whose argument was rejected? Well, there are exceptions to every rule. We're talking about that last class. Right? If Scalia wrote the dissent, and if Scalia is one of the justices you're desperate to try to pick off from the other side, then quote a Scalia dissent and say to Scalia, like, hey, remember that thing you wrote before? You were saying something that is good for me. It's good for our side here. So keep saying that. Keep saying that. So I think Verrilli also doesn't know your audience. I like his theme. Right? When the government is the employer, the government gets wide latitude, even to restrict speech. That's an argument that could conceivably appeal to some of these kind of like conservative, extremist judges who he's trying to pick off. And then I also think he has a nice structure. So something we've talked about all year, CREAC rule explanation before rule application. Pages 12 to 15 of his brief, he explains the rule. And then I'm beginning at page 15, he applies that rule to the facts here. He says, here's the general rule for government employment speech, and now I'm going to apply that rule to Abood and the union speech here. Right, things that you liked, things that you didn't like. And every year I'd say, like, the Carvin brief in particular, like, a good half of the class will say, like, this is, like, maybe my least favorite brief of the semester. And then, like, a good, like, 10% of the class will be like, this is my favorite brief of the semester. So, things you didn't like, things you liked? Yeah, Kelsey.
Talking about Snyder versus Phelps and how that speech was upheld, and, like, I know the background of that case, and, like, I think using that was like a good way to show, hey, this is okay, so like this should be political speech too, is a good strategy.
Good. And so Carvin does that. And tell us what Snyder v. Phelps was about in like a sentence or two.
Westboro Church picketing military funerals, just saying awful things and disrupting funerals of military members.
Yes. So Westboro Baptist Church has these like incredibly homophobic, racist, vile views, and they decide to promote those views where they can get the most attention. One of those places is by picketing the funerals of service members, and so they did this, and they got sued for it. And the Supreme Court, 8-1, said Westboro Baptist Church's right to picket is protected by the First Amendment free speech clause. And so what Carvin says, as Kelsey was saying, is I think like, a pretty a point that would appeal to a wide audience, which is if we're going to hold our nose and protect that Westboro Baptist Church speech, then surely we should protect speech about how big the government should be. Surely we should protect core political speech that's been protected by the First Amendment for centuries. So I think a clever use of Snyder v. Phelps. Good. Other things? Yeah, Elizabeth.
I love the bridging in the first brief, but I hated this one paragraph on page 26 of the supplement.
Good. Let's see. Yep.
So
which one?
In the middle, it's a paragraph that's really one sentence. The same is true for other professions, and then a paragraph of citing. And I hated it, and it like distracted me from everything else because I just think like that's just so ugly. Why'd you do that? So that was one of those times.
What's a better way to do it? I don't disagree with you.
I put it in the footnotes or something.
Put the sites in the footnote, and
Yeah.
also maybe like
And
maybe bullet
explain.
point the profession. So the same is true for other professions. Colon.
Yeah.
And then what? Police. What are the other professions are?
Yeah, see, it's hard to even like read through
Yeah.
because it's just,
All you
I
can
just
see is
really
police
didn't get
unions.
it.
Yeah.
At all.
Yeah. Yeah. No, I agree. I agree with that. Michaela.
I like Verley's better, but.
Good. Tell us about Verley's. Or
I
about.
feel like he, like you said, he did pre-act, so he outlined what the issue was, what we're talking about. He kind of like took you where you needed to go quickly, and I just liked it. It's like, and then he put his argument up front, and then he addressed his counter arguments quickly, and then basically shut it down as quick as possible.
Awesome, and that's what we always want to do with counter arguments. Don't ignore them, acknowledge them quickly, and then spend most of your time on the attack, shutting them down. Good. I do think that Verley's brief is well structured, which is a trademark of Solicitor General briefs. I think, yeah, Sharia.
So in the last Judith Fisher, it said to not use clearly or obviously.
Okay.
And he uses it, and I was wondering if it fit or not.
If it
On
works or
page,
doesn't work, which page?
18.
18
Supplement
Verley's?
or-
18 at the bottom, 20 at the top.
Oh, let's see. And where on the page?
Bottom paragraph. Yeah, the last paragraph. Second sentence.
Okay. So California's agency fee law forces petitioners to subsidize respondent unions' political speech, and is thus subject to exacting scrutiny. Also, I don't like the petitioners and respondents thing. It's hard to who can remember who's the petitioner, who's the respondent, and is thus subject to exacting scrutiny. That is clearly the general rule in the public union context. I don't like clearly there. I think like just say that is the rule in the public union context. Makes the same point, and it omits a word, needless word, and also it doesn't give the impression that maybe you're overcompensating. If you look at his Roman numeral 1 subject heading on page 14 of the supplement, 16 of the brief, he doesn't say Abood should clearly be overruled, Abood should definitely be overruled, Abood should definitely, clearly, obviously be, just Abood should be overruled. Short, sweet, make the statement and then back it up. Good catch. Yeah.
What about on right next to that, page 19 in the supplement, the middle paragraph? It says that distinction is, to say the least, counterintuitive. You don't just say that distinction is counterintuitive.
Yeah, I think so. He's being snarky here, he's saying that distinction is counterintuitive, and there might be a whole lot of other things wrong with it too. It could be wrong for multiple reasons to do that. One is it may be just distracting, and breaks up the sentence. Like, what are we talking about? Keep subject, verb, object together. Here it's not an object, but a predicate adjective together with the verb. But then also, it also may rub the audience the wrong way in terms of like, just make your point. Don't do bells and whistles.
I think there's a couple of times in that paragraph, like at the bottom of that paragraph, there's the in between commas in one context, and in the middle, like it would seem to necessarily prohibit. Like I feel like you can just say those things a little more affirmatively.
Yeah, so it would seem to necessarily prohibit. You could just say it prohibits.
Yeah.
Yeah, I don't disagree with that. I think these are great things to keep an eye out for when you're reading, and to the extent they bug you when you read them, avoid them as a writer. That distinction is, to say the least, counterintuitive, kind of like an aside. And apparently, I haven't read enough of it to notice, but apparently there's a Twitter handle called Gorsuch Style, which makes fun of Justice Gorsuch's writing style. And so one of the trademarks of Gorsuch Style is he just states like the most obvious thing, as if it's like a profound insight. But then another aspect of it is like lots of like asides that he puts in parentheticals. So you could imagine Carvin, if this were Gorsuch Style, would be that distinction is parentheses, to say the least, close parentheses, counterintuitive. So anyway, poor Gorsuch. He's apparently very unpopular on the court. Everyone hates him. Not everyone, but Okay, so now let's listen to some more arguments.
Yes, I love this. It's like a movie.
I would do that.
No video, just audio with captions.
I don't know what they look like, but I picture it in my head.
Okay, now I do whenever Jess is talking and like this.
Can we just take a second and appreciate RBG?
You're going to listen to it.
I'm just
Listen
teasing.
to it.
I'm
Great.
just
Take
teasing.
it in. Take it in. All right. Just make a joke. That's how great RBG is. She comes with her own
Love it.
Something that Justice Breyer said, you didn't respond directly to it. He said, if Abood falls, then so do our decisions, Keller, on mandatory bar association, on student activities fee. Do you agree that that would be a consequence of your theory?
Well, no. In fact, that hypothetical was completely eliminated by Harris, which made it quite clear that neither Keller nor Southworth was in any jeopardy because the rationale of those cases was significantly different than the rationale of Abood.
Those cases
Keller
start with Abood, Mr. Carvin. Those cases say Abood is the framework, and those cases decide the questions that they decided specifically within that framework.
A lot of cases cite cases, but the question...
Not a cite, it's this is the way we look at mandatory fee cases.
Again, I must respectfully disagree. They do have that in common at that level of generality. But there's a key distinction, as Harris itself pointed out, between giving money to a bar association and giving money to a union. The key thing is that the bar association is a non-speech restriction. It's like what the court said in the Glickman commercial speech context. The initial association has nothing to do with speech. There it was regulating lawyers, not advocating on behalf of lawyers.
Bar associations do things all the time that lawyers disagree with. They engage in certain kinds of litigation and not other kinds of litigation. They take public policy positions on certain issues and not other issues. I mean, I think it would be impossible to make a distinction along that score.
Keller struck down those kinds of activities by bar associations, taking positions on federal jurisdiction, taking position on gun control. It said they could only spend...
Do you think bar associations...
Okay, so let's pause there, and I'm going to pick it up right back up here in a second. But I want to point out, so she's asking a tough question that is dangerous for him. Here's what's tough about it. Okay? She's saying, if you're right in this case, doesn't that mean that a precedent called Keller was wrong? And the obvious answer for him, I think, is yes. Who cares? Why does he care about Keller? Keller said it's okay for a bar association like the KBA to require you all, when you're attorneys, to pay dues. And then it's going to use those dues for like various things various things. So Keller said that's okay. And the logical implication of Carvin's position is that Keller was wrong. But why can he not say that Keller was wrong? Because he needs the votes of two justices who were in the Keller majority, Scalia and Kennedy.